case briefs, and so much more. LSData's got what you're looking for.
In 1986, the Delaware Court of Chancery wrestled with the complex legal and financial dispute surrounding the control of Anderson, Clayton Company, a case with major implications for the level of obligation a board of directors owes to their shareholders. At the center of contention was the competing tender offers for shareholders by AC Acquisitions Corp., a shell corporation formed by Bear, Stearns & Co. Inc., Grass Petroleum Corp., and Grass Partners, collectively referred to as BSG, for $56 per share, and Anderson, Clayton Company, who countered with a self-tender offer for $60 per share on 65% of the outstanding stock. Anderson, Clayton Company also planned to set up a new employee stock ownership plan, ESOP, representing 25% of all issued and outstanding stock. The plaintiffs, BSG, alleged that Anderson, Clayton & Co.'s board had breached its fiduciary duties to the shareholders, countering the company's defense that this course of action was a reasonable alternative to liquidation. The court found that the company transaction led by Anderson, Clayton & Co. failed to meet the standards of the UNOCL test, which evaluates whether a company's defensive measures are reasonable and proportionate to the threat the company faces. The court concurred with the plaintiff's arguments that the self-tender was structured to dissuade shareholders from accepting the tender offer from BSG, essentially constituting a coercive defensive strategy and hence a breach of fiduciary duties. In trying to find a middle ground, the court proposed a conditional and temporary injunction to eliminate the coercive elements of the company transaction. This injunction would allow shareholders to choose the company's offer if a majority found it preferable, with the contingency that the plaintiffs would provide adequate notice and pledge to acquire or return tendered shares. A crucial takeaway from the court was the importance of announcing an alternative transaction if a majority of shareholders rejected the BSG offer. Without such an alternate arrangement, the court warned that the board's decisions would not be safeguarded by the business judgment rule.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.